This is a reference from the High Court of Kuching and of course the High Court of Kuala Lumpur. There are three references that were jointly heard by the Federal Court today, all of which dealt with the question of the constitutionality of the offence of street protest under the Peaceful Assembly Act. In all cases, the trial courts referred the question to the High Court and subsequently the High Court to the Federal Court before the commencement of the trial. In other words, we raised in those courts at the outset questions as to validity of the charge. That, of course, has come up and reached the Federal Court today, but the learned judges of the Federal Court have expressed a view that the question as to whether a street protest was actually held be determined by the trial court first, before they are called upon to consider the constitutionality of that provision. So there are two ways of looking at it. One, of course, is to argue that at this stage, because the charge sets out those words, it's something that the Federal Court can decide. But the other, of course, is to get the factual metrics put in place first, which is what the learned Chief Justice suggested. As I understand it, what has happened now is there's no order made on the reference, and the position is that we go back to the trial courts and we proceed with the trial until a finding is made, probably at the close of the prosecution's case or before that, as to whether or not there's a street protest. Upon that finding, then a reference, the parties are at liberty to file a reference to the High Court again and come back to the Federal Court for them to then consider the position.